Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Let's go back to California. This time a little farther away from San Francisco. We're going to go to Santa Monica. And here, I see how this happens. I have one question, and I want to know which will be what was the policy, the medical policy. But here we have in April of 22, we have a physician who suffers a ground level fall. I think his wife is also a physician. So you got two physicians on scene. EMS gets called. Look, and you could play this out so easily. They don't take spinal precautions. In fact, the doctor on scene, the wife, I think, tries to say, you need to do C-spine, back pain, spinal precautions. They basically, allegedly, this is all alleged, right? This is all lawsuit, not a decision, but they claim that EMS told them, go leave us alone, get out, we've got it. And that they, as physicians, that they were relieved of control. I could see how that happens. And that they continue to fail to take spinal precautions. They put the person on a soft stretcher and then sat him up and then laid him down. And all this time he was complaining and in pain. I don't know what they were thinking at the time, but nonetheless, they brought him down a flight of stairs and it was, jolting him up and down.
I believe they put him in a stair chair, at least according to the allegations.
And it looks like a collapsible one, but in any event, he's going up and down, right? Through his movements are sitting up, sitting down. The emergency physicians report that he has a very serious neck injury, and basically they ignore him. So at the hospital, he ends up being urgently admitted, taken for surgery on his C-spine. His diagnosis was, in fact, cervical compression and central spinal cord syndrome injury. He's now a quadriplegic. Mm-hmm. So here's the thing. This is what I want to know. Two things, critical things. One on negligent care is what was the policy, right? Normally, and look, EMS is getting away from spinal precautions, C-spine precautions, and they're allowing nationally EMS to clear you in the field. Here, you've got mechanism of injury and you've got complaints of pain. So I don't know how anyone could be cleared, right? These are just my questions. But so that's on liability, right? Did they either not follow a policy or did they exercise discretion? That matters. Was their discretion so likely to cause injury, right? It ignored an obvious complaint. But here's the second part. So it seems like they've got a strong liability case without knowing much more. But the next part is as to proximate cause. Remember, for everybody listening, to prove negligence, a claim of negligence, you got to prove there was a duty and they breached a duty. They may very well have that here if this is accurate. But then the breach of your duty has to directly result in the injuries. I want to know, was he moving his toes, right? Was he able to move his extremities on scene? Because if he was not, then proving proximate cause that your failure to protect the C-spine directly relating his injuries, that may be very difficult. They may, if I'm them, they may, concede to liability, right? And fight over how you're going to prove proximate cause and how do you prove that? Right? Because it's going to be very difficult. So my guess is this results in a settlement up to the insurance limits. And why do I say up to the insurance limits? Well, you've got a physician. I don't know how old he is unless you know, but who's now incapacitated, can't be a physician. Okay, if he was retired, that's one set of damages. If this guy's 40 or person's 45 years old and had another 20 years of practice, we got some big money. The question is, what is the insurance limits? Now, we're in Santa Monica. So the insurance limits are the taxpayers' purses, right? You're not broke until your last taxpayer's broke when you sue a municipality. So the insurance will inevitably, I'm guessing, offer their limits. Probably if I had to guess in California, I'm assuming 5 million with a 10 million umbrella. $10 million will probably put up after some discovery and whatever. But my bet is the next thing you're going to see out of this is a confidential settlement. But again, proximate cause is very difficult. If he wasn't moving his toes on scene, how do you prove it? If he was moving his toes on scene, someone's paying a big amount of money.
Yeah, I just don't understand a couple of different parts of this. Number one, you've got a medical professional on the scene. You've got, even if you don't consider the patient, because not really in a position to take responsibility for a patient, but the wife is a medical doctor. And it's inconceivable to me that someone would identify themselves as a medical doctor and the paramedics would say, we're not going to listen to you. Usually the conversation goes something like this: Doc, do you want to take responsibility for the patient?
Yep.
And then you either get a yes or a no, but you don't get, I'm a doctor, get out of our way. It's, do you want to take responsibility? Yes or no. If you don't want to take responsibility, then get out of the way. So I think that's one of the questions that I've got. Now, if the wife is a dermatologist or something of that nature and says, no, this is outside of my area of responsibility, now you've got a different situation. Okay, so that's number one. Number two, it's just inconceivable to me that someone who fell would not have been evaluated for C-spine or some sort of neck and back injury, just based on the end result injuries. It's just inconceivable to me. So I really wonder whether or not factually the complaint is accurate as to what they were told, whether they were basically saying, we don't want any help, just help them get up, or something, and that would just get us to the hospital. I really question what actually happened there. It doesn't make sense.
And this is why I like body cams for EMS as well as fire. Fire's a little harder, but EMS, I like body cams because it's just like any other medical situation. He said, she said, what you were told matters. And it's easy to make the fire department or the, paramedics, the bad guys, bad people on this. And I agree. This is so hard to believe it happened. We don't know. We have, right? But even if I was defending this, I'd say, well, prove to me that he wasn't a quadriplegic when you picked him up.
And right. And I think that's what we call causation is going to be one of the big things. Because if the damage was already done from the fall, then what the medics either did or didn't do is irrelevant to his condition.
Right. So it's like dropping somebody with a hip fracture, and the only thing they got after you dropped them is a hip fracture. It's so okay.